Calling civil case 092292, Kristen Perry et al. Versus Arnold Schwarzenegger et al.
Well, this is an impressive array of legal talent. All this legal talent seems to be focused on one person at the moment. Welcome back. I'm delighted to have you back. Obviously, the hiatus we've had, the period of time from the presentation of the evidence to the present, is not anything that I would have or wished for or hoped for. I was hoping that we would get this case in before the present. But it may be appropriate that this case is coming to closing argument in June. June, after all, is the month for weddings. So you have received the schedule. We've allotted the day for your presentations, and I would simply propose that we get right to business. Mr. Olson, are you leading off for the plaintiffs?
I am, Your Honor. Mr. Boutros has one housekeeping matter we would like to bring to your attention before I start.
All right, that's fine.
Good morning, Your Honor. With the court's permission today, during closings, Mr. Olson will be playing some of the video clips from the trial proceedings. We propose, if this works for the court, that at the end of the day, we would offer the transcript pages for the record whenever it's convenient for the court, rather than doing it for the closings. Then we'll have that for the record.
That would seem to make sense, does it not, Mr. Cooper?
I'm sorry, Your Honor. I'm not sure I followed the proposal.
Maybe you can clarify.
I can clarify. We will be playing video clips from the trial proceedings during the closing arguments. At the end of the day, or whenever it is convenient for the court, we would offer it into the record. We would offer into the record the transcript pages of the clips that we have played in the court, marked as exhibits for the record.
I understand and see no objection to that, Your Honor.
Fine, that will be fine.
Thank you.
Any other housekeeping? Good. Mr. Olson?
Thank you, Your Honor. Theodore B. Olson on behalf of the plaintiffs. May it please the court, we conclude this trial, Your Honor, where we began. The case is about marriage and equality. The fundamental constitutional right to marry has been taken away from the plaintiffs and tens of thousands of similarly situated Californians. Their state has rewritten its constitution in order to place them into a specific disfavored category where their most intimate personal relationships are not valid, not recognized, and second-rate. Their state has stigmatized them as unworthy of marriage, different, and less respected. Because marriage is at the heart and soul of this case, I want to immediately turn to the subject of marriage and what we have learned during this trial about what it means to be able to marry and then to have that right extinguished. I will focus on marriage from four perspectives, as seen by the proponents of Proposition 8, the Supreme Court of the United States, the plaintiffs, and the experts who came forward to share their knowledge and experience on the subject of marriage and those subjects during this trial. First, the proponents. In the words of their lead counsel, the central and defining purpose of the institution of marriage, what it has always been, is to promote procreation and to channel narrowly procreative sexual activities between men and women into stable, enduring unions. He went on to say, the core need that marriage aims to meet is the child's need to be emotionally, morally, practically, and legally affiliated with the woman and man whose sexual union brought the child into the world. It is quite clear from these statements and other statements made by the proponents during the trial, Your Honor, that the proponents of marriage and the proponents of Proposition 8 see marriage as an institution of, by, and for the state, and to promote procreation and the raising of children by their biological parents, an institution to promote the state's interests. And proponents' counsel added, in response to your question, Your Honor, that racial restrictions were never a definitional feature of the institution of marriage. At times during the trial, the proponents predicted grave consequences if same-sex marriage were to be legalized in California. For example, you asked, how does permitting same-sex couples to marry in any way diminish the procreative aspect or function of marriage, or denigrate the institution of marriage for heterosexuals? Lead counsel responded, Your Honor, because it will change the institution. If the institution is deinstitutionalized, he said, Mr. Blankenhorn will testify that will likely lead to very real social harms, such as lower marriage rates and high rates of divorce and non-marital cohabitation, with more children raised outside the marriage and separated from at least one of their parents. It is revealing, it seems to me, that the deinstitutionalization message is quite different from the thrust of the proponents' Yes on 8 election campaign. That, in the words they put into the hands of all California voters, focused heavily on protect our children from somehow learning that gay marriage is okay. Protect our children from learning that gay marriage is okay. Those are the words that the proponents put in the ballot, in the voter information guide that was given to every voter. That was not a very subtle theme, that there is something wrong, sinister, or unusual about gays, that gays in their relationship are not okay, and decidedly not suitable for children. But that children might think it was okay if they learned about gays getting married like normal people. For obvious reasons, the gays are not okay message was largely abandoned during the trial in favor of the procreation and deinstitutionalization theme. And after promising proof that people might stop marrying and cease procreating if Proposition 8 were overturned, the proponents switched course from that platform as well and affirmatively argued that they actually had no idea and certainly no evidence that any of their prognostications would come to pass if Proposition 8 were to be enacted. Their counsel asserted, in his words, the reality is that you will hear nothing but predictions in this trial about what the long-term effects of adopting same-sex marriage will be on the institution of marriage. It is not possible, he said, to render reliable and certain judgments on these things.
But it is the plaintiffs, after all, who must bear the burden of proof, do they not, Mr. Olson?
Yes, and I want to juxtapose the burden of proof with respect to, yes, we have a burden of proof up to a certain point, depending on the standard of review. But I thought it was very important to juxtapose.
And that standard of review being rational basis?
No. We believe, as we've articulated during the course of the trial and memoranda that we submitted just yesterday, that strict scrutiny is required here because this is a discrimination, the taking away of a fundamental right as articulated by the Supreme Court. It's a putting the plaintiffs and others like them in a suspect classification based upon sex and sexual orientation. Those two things, under the Equal Protection Clause and Due Process Clause, justify strict scrutiny.
Now, are you focusing on the facts pertaining to the California initiative or facts pertinent generally and throughout the country with respect to marriage?
Both of those. And then what I was going to do, with Your Honor's indulgence, is juxtapose what the plaintiffs have said their position is about what marriage is all about and what Proposition 8 would do with these other four perspectives, the Supreme Court, the plaintiffs themselves, and the expert witnesses. But I wanted to complete that one point, that the proponents have shifted from protect our children to procreation and deinstitutionalization.
Does that make any difference?
I think it does make a difference because I think it suggests the vacuum that exists in connection with the attempt by the proponents to provide a basis for what Californians did in November when it passed Proposition 8. Proponents' counsel,
The
Excuse
Supreme
me.
Court's decision in Cloverleaf, the Minnesota versus Cloverleaf case, what the Supreme Court told us there, that was an equal protection case, of course, is that any debatable proposition will support the enactment. And while one challenging on equal protection grounds can certainly introduce evidence that the classification is irrational, if there's any debatable proposition in support of the classification, it passes muster.
well, it has to be a debatable proposition, not that there's a debate about a proposition.
What's the difference?
Well, the difference is, as the Supreme Court said in the Romer case, there has to be a rational objective that the government is seeking to sustain, and that the measure itself will advance that rational proposition. Now, the Supreme Court looks at this issue in various different ways, depending on upon whether we are talking about strict scrutiny or intermediate scrutiny, or as it did in the VMI case, in the gender discrimination context, or in the rational basis case. But what the Supreme Court did say in the City of Cleburne case, that mere negative attitudes, fear, or unsubstantiated factors or assertions won't be sufficiently cognizable. And there's an irrational basis case involving retarded persons in housing. And proponents' counsel said, it came down to this: same-sex marriage is simply too novel an experiment to allow for any firm conclusion about its long-term effect on societal interests. They just don't know. This is the essence of the case as it comes to the end of the trial and to the closing arguments. They just don't know whether same-sex marriage will harm the institution of heterosexual marriage. And I submit that the overwhelming evidence in this case proves that we do know. And the fact is that allowing persons to marry someone of the same sex will not, in the slightest, deter heterosexuals from marrying, from staying married, or from having babies. In fact, the evidence was from the experts that eliminating invidious restrictions on marriage strengthens the institution of marriage for both heterosexual and homosexual persons and their children. In the face of all this evidence going in one direction, proponents' arguments of last resort, that the absence of evidence or logic as a justification is a justification of their various positions, but is nothing but a fig leaf for the fact that after a 3-week trial and an opportunity to present any expert witness they wished, the very best case that the proponents could muster and measure, arrange for us, or put forth for you is to argue that Proposition 8 is constitutional because California voters don't know whether allowing gays or lesbians to marry would discourage heterosexuals from procreative marriage, procreative conduct. Well, that is what the proponents say about marriage and the threat to their concept of the institution of marriage from allowing marriage by persons of the same sex.
Well, they have identified a difference between opposite-sex and same-sex couples in that opposite-sex couples can procreate without the intervention of some third party. That is a difference. Mm-hmm. And why is that difference not one that the legislature, or in this case, the voters, could rationally take into account in settling the marriage laws in the state of California?
As I said, they have to identify something that ties in with the subject matter of the legislation or constitutional provision that they're advancing. Yes, heterosexual people are able independently to procreate. Homosexual people may have that same capacity, but in their relationships, that is not something that occurs. But we're talking about, because of that, taking away the right of an intimate relationship that the Supreme Court has called the right of privacy, the right of liberty. And you'd have to explain or make some statement that allowing these other individuals that we represent here today to engage in the institution of marriage will somehow stop that procreation or stop people from getting married or cause them to get divorced. That's one of the positions they took. And then they said they don't know.
Doesn't California accommodate gays and lesbians by providing domestic partnership rights, which are essentially all the rights associated with marriage? Why isn't that sufficient accommodation?
Well, as the experts pointed out, and as the plaintiffs, and I'm going to, in a moment or two, with your permission, play some excerpts from the testimony of both the plaintiffs and the expert witnesses on that very subject. What marriage means versus something called domestic partnership, which means something completely different. But what I first wanted to do was recite briefly the second perspective on marriage. Now, we've heard the proponent's perspective on marriage, and you've alluded to that in your questions to me. I think it's really important to set forth the prism through which this case must be viewed by the judiciary. And that is the perspective on marriage, the same subject that we're talking about, by the United States Supreme Court. The Supreme Court, the freedom to marry, the freedom to make the choice to marry. The Supreme Court has said in, I counted 14 cases going back to 1888, 122 years, and these are the words of all those Supreme Court decisions about what marriage is. And I set forth in this distinction between what the plaintiffs have called it and what the Supreme Court has called it. The Supreme Court has said that marriage is the most important relationship in life. Now, that's being withheld from the plaintiffs. It is the foundation of society. It is essential to the orderly pursuit of happiness. It is a right of privacy older than the Bill of Rights and older than our political parties. One of the liberties protected by the Due Process Clause, a right of intimacy to the degree of being sacred, and a liberty right equally available to a person in a homosexual relationship as to a heterosexual person's. That's the Lawrence v. Texas case. Marriage, the Supreme Court has said, again and again, is a component of liberty, privacy, association, spirituality, and autonomy. It is a right possessed by persons of different races, by persons in prison, and by individuals who are delinquent in paying child support. It is a right of individuals, not an indulgence dispensed by the state of California or any state to favored classes of citizens, which could easily be withdrawn if the state were to change its mind about procreation. In other words, it is a right belonging to Californians, to persons. It is not a right belonging to the state of California. And the right to marry, to choose to marry, has never been conditioned on or tied to procreation. It hardly could be rooted in the state's interest in procreation, since the right to marry in the Supreme Court cases has been invoked sustaining the right to contraceptives, to divorce, and just a few years ago in that Lawrence case, to homosexual.
Well, if the right belongs to Californians individually, why cannot Californians collectively establish the parameters of the right?
Well, they can, unless they are taking away a fundamental right to marry under the Constitution with a compelling governmental interest and a proposition that...
Would this case be different if the California Supreme Court in marriage cases had invalidated the 18,000 or so marriages that were performed from, I believe it was June or May?
It was June.
2008 until November?
Yes.
Would this case be different?
It would be different.
In what way?
It would be much worse.
In what way?
It's worse this way. Right now, California has 18,000 same-sex marriages, if we can call it that for a moment. Heterosexual persons who can marry the person in their choice. If they are a child molester, if they are a wife beater, if they're in prison for 15 murders, they can marry the person of their choice if they are heterosexual. Individuals, such as the plaintiffs in this case, and those who are similarly situated, may not marry the person of their choice. We have a 3 strikes law in California. You can go to prison for life, but if you're a homosexual, you can't get married. There's that category. The people that can get married, the people that can't get married. There's 18,000 people that were married during that period that you described who are legally married. But if they get divorced or if they are widowed, they can't remarry. And they can't even remarry the same person in the case of a divorce because the Constitution wouldn't recognize it.
No, but wouldn't the marriage regime in California be more rational if, in fact, the California Supreme Court had invalidated those 18,000 marriages?
It would be less irrational. I don't think it would be rational at all because the distinction that's being made, and by the way, there's a fourth category, people that got married in other states when during a certain period of time or after a certain date and who came to California. Now they are living in California in a same-sex relationship and their marriage is recognized. So there's 4 different categories. If you reduced it to 3, yes, it would be less capricious and less arbitrary, but that wouldn't make it constitutional.
Why not?
It would not make it constitutional because there is not a compelling governmental interest to put the plaintiffs in a class like this and take away what the Supreme Court has called a fundamental right, a right of liberty, privacy, association, intimacy, and autonomy. You are taking away, the state is, that fundamental right. And even if we did, and even if it was intermediate scrutiny, you can't rely in the VMI case. For example, United States versus Virginia, the Supreme Court said you can't make this up after the fact. The post hoc rationalization won't work. One of the reasons I explained to you the shift in position is to show you that the rationalizations that were being offered at the end of the trial were different than the motives that were in the ballot proposition and the advertising. These have become post hoc rationalizations because the proponents don't want to come in here and say we passed or the people passed Proposition 8 because they don't think gays are unusual. They don't want our children to know about them. That sounds an awful lot like animus. So the rationalization now is procreation and something called the deinstitutionalization of marriage, whatever in the world that is. I think is really important, given what the Supreme Court has said about marriage and what the proponents said about marriage, to hear what the plaintiffs have said about marriage and what it means to them in their own words. They have said that marriage means, and this means not a domestic partnership, this means marriage. The social institution of marriage that is so valuable that the Supreme Court says it's the most important relationship in life. The plaintiffs have said that marriage means to them freedom, pride. These are their words. Dignity, belonging, respect, equality, permanence, acceptance, security, honor, dedication, and a public commitment to the world. One of the plaintiffs said, it's the most important decision you make as an adult. Who could disagree with that? I would like, with your honor's permission now, to play a couple of excerpts from the testimony by the 4 plaintiffs, starting with the plaintiffs Katami and Zarillo, explaining why they want to marry because they can say it better than I can. This is, first of all, Plaintiff Katami, followed by Plaintiff Zarillo. What do we have to do? Okay, thank you.
Why did you want to get married?
Well, there are many reasons. I think the primary reason for me is because I've found someone that I love and I know I can dedicate the rest of my life to. And when you find someone who's not only your best friend, but your best advocate and supporter in life, it's the natural next step, for me to want to be married to that person.
Mm-hmm. Now, today you are in a committed relationship with another gay man, correct?
Yes, sir.
Tell me a little about that man.
He's the love of my life. I love him probably more than I love myself. I would do anything for him. I would put his needs ahead of my own. I would be with him in sickness and health, for richer, for poorer, death do us part, just like vows. I would do anything for him, and I want nothing more than to marry him.
And now Plaintiff Kristen Perry. If the courts of the United States were ultimately decided that you and other same persons seeking to marry someone of the same sex did indeed have the constitutional right to get married, do you think that would have an effect on other acts of discrimination against you?
Objection, Your Honor, speculation.
Close, but objection overrules state of mind. You may answer.
I believe for me personally as a lesbian that if I had grown up in a world where the most important decision I was going to make as an adult was treated the same way as everybody else's decision, that I'd not have been treated the way I was growing up or as an adult. There's something so humiliating about everybody knowing that you want to make that decision and that you don't get to do that. You know, it's hard to face people at work and the people even here right now. Many of you have this, but I don't. So I have to still find a way to feel okay and not take every bit of discriminatory behavior toward me too personally, because in the end, that'll only hurt me and my family. So if Prop 8 were undone and kids like me growing up in Bakersfield right now could never know what this felt like, then I assume that their entire lives would be on a higher arc. That they would live with a higher sense of themselves and it would improve the quality of their entire life.
And plaintiff Sandra Steer, tell us what it means to you as a plaintiff in this case. If you were to be successful, how would it change your life?
Well, I think it would change my life dramatically. The first time somebody said to me, "Are you married?" and I said, "Yes," I would think, that feels good. It feels good and honest and true. And I would feel more secure. I would feel more accepted. I would feel more pride. I would feel less protective of my children. I would feel less like I had to protect my kids or worry about them or worry that they feel any shame or sense of not belonging. So I think there are immediate, very real, and very desirable personal gains that I would experience. And, of course, close family. But on a different level, you know, as a parent, you're always thinking about that other generation, that next generation, because, you know, they're in your house. So you are constantly thinking about the world that the society that you're in, and what you're doing for them. Are we building a good world for them? And I really want that. I want our kids to have a better life than we have right now. When they grow up, I want it to be better for them and their kids. I want their lives to be better too. So I really think about that generation and the possibility of having grandchildren someday and having them live in a world where they grow up and whoever they fall in love with, it's okay, because they can be honored and they can be true to themselves and they can be accepted by society and protected by their government. And that's what I hope can be the outcome of this case in the long run. And as somebody who is from one of those conservative little pockets in the country where there isn't necessarily a lot of difference in the types of people that are there, having these legal protection is everything. It's important for these kids that don't have any ready access to all types of people to at least feel like the option to be true to yourself is an option that they can have too. And that's what I hope for. I hope for something for Chris and I. But we're big, strong women. You know, we are in a good place in our lives right now. So we would benefit from it greatly. But other people over time, I think, would benefit in a much more profound, life-changing way.
If we had the time, Your Honor, I could not present a more compelling closing argument than simply replaying the testimony in its entirety than the four plaintiffs and Helen Zia. They have described from their hearts what marriage means to them, what it does to them, and says about them to be denied that right. If we did nothing else in this trial, that would be enough. And the two plaintiffs, Perry and Steer, are in a domestic partnership relationship. You will recall during the trial, it isn't the same thing. But we have so much more. There were 8 experts, persons who have studied and written about American history, marriage, psychology, sociology, economics, and political science throughout their entire professional lives. I have the time to discuss just a segment of what they had to say, but their evidence was remarkably powerful, persuasive, and very consistent. Professor Cott, for example, explained that contrary to proponents' assertion, marriage is not primarily a vehicle by which the state promotes procreation. She's an expert in marriage. She testified that its core social meaning, marriage, is a couple's choice to live with one another, to remain committed to one another, and to form a household based on feelings about one another, and their agreement to join in an economic partnership and support one another in terms of the material needs of life. She said it is an aspect of liberty, basic civil right. The ability to marry is the expression of one's freedom. Those are the same things coming from the expert on marriage that the Supreme Court has been saying for 122 years. And contrary to proponents' assertions, racial restrictions have indeed been a definitional feature of marriage. For example, as we learned from her, slaves were not permitted to marry until the Emancipation Proclamation. And she testified, and I would like to play that excerpt, if we can do the same mechanical things to have her testify what it meant to the slaves.
Well, what happened when the slaves were emancipated?
When slaves were emancipated, they flocked to get married, and this was not trivial to them by any means. They saw the ability to marry legally, to replace the informal unions in which they had formed families and children, many of them, to replace those informal unions with legal, valid marriage in which the states in which they lived would presumably protect their vows to each other. In fact, one quote that historians have drawn out from the record, because many of these ex-slaves were illiterate, of course, but one quotation that is the title of an article a historian wrote. It was said by an ex-slave who had also been a Union soldier, and he declared, "The marriage covenant is the foundation of all our rights." Meaning that it was the most everyday exhibit of the fact that he was a free person. He could say "I do" to his partner.
What a powerful statement that slave made. The marriage covenant is the foundation of all our rights. It exemplifies freedom. He could say "I do" to his partner. Then Professor Cott explained the meaning and definition of marriage. Now, she is just about the leading expert. Certainly the finest expert we could find to talk about the history of marriage and its definition in American society and American culture, and what it means to individuals in the society to be able to be married and to have the choice of the person to whom one would marry.
To go back to something you mentioned a moment ago, what do you today, based on the collection of events that made up our history as a nation, view as the key defining characteristics of the institution of marriage in the United States?
So mutual consent between partners who freely choose each other and their commitment to establishing a continuing stable relationship as the foundation for a household in which they will economically support one another and their dependents and enable themselves to compose a family.
Do you believe that a law recognizing the ability of individuals of the same sex to marry would be consistent and would include those characteristics you have just identified as being defining?
Yes.
Why?
It seems to me that couples of the same sex have expressed many of the same motivations as couples of different sex to marry and to establish stable households. It seems to me that couples of the same sex have expressed many of the same motivations as couples of different sexes to marry and to establish stable households. And in that regard, especially in an era when families can have children that are not the result of biological procreation, and so many families do, that it seems to me same-sex couples fulfill the aims of marriage from the point of view of the state. And certainly it's up to any partner, intimate pair, to decide whether they wish to be married or not. But seems to me that by excluding same-sex couples from the ability to marry and to engage in this highly valued institution, that society is actually denying itself another resource for stability and social order.
So we learned, also during the trial, that racial restrictions on the right to marry were finally eliminated for good in Loving v. Virginia in 1967, ending laws like Proposition 8, which prohibited certain marriage choices for citizens that had once existed in 41 states. Proposition 8 is very, very much like those restrictions, Dr. Cott explained, and designates gays and lesbians as less worthy and entitled to less honor, less status, and fewer benefits. Marriage is special, the experts tell us. Domestic partnerships and civil unions are pale comparisons. As Dr. Cott put it, there is nothing that is like marriage except marriage. And the state's approval lends prestige and acceptance to the institution. As Dr. Peplau testified, married couples are healthier, live longer, are emotionally more stable, and better off on every measure of health. Domestic partnership is a harmful structural stigma. That's what Dr. Ilan Meyer said. Moreover, removing the stigma imposed by Proposition 8 would produce powerful collateral benefits. Here is Dr. Meyer, one of the world's leading experts on stigma and discrimination.
Dr. Meyer, do you see a connection between the concealment process and Proposition 8 in its denial of marriage rights?
Well, again, to the extent that we see Proposition 8 as a part of the stigma, as something that propagates the stigma, it certainly doesn't send the message that it's okay, you can be who you want to be. You know, we respect that. We welcome you as part of the community. It sends the opposite message in my mind, and therefore would, I would think, add to that pressure, to that social environment that encourages people, some people, to conceal. And also, when I talk about those effects of Proposition 8, by the way, they don't only affect gay people. They also send the same message to other people who are not themselves gay. So in this sense, it's not just damaging to gay people because they feel bad about their rejection. It also sends a message that it is okay to reject. Not only that it is okay, that it is very highly valued by our Constitution to reject gay people, to designate them a different class of people in terms of their intimate relationships.
I was struck, Your Honor, by that same word appearing again and again. That word, okay. Sandra Steer just wanted her children to feel okay about who they were and who they were living with. Their parents, they just wanted to feel okay. It was okay to be gay. The proponents in their voter information guide, they told every voting citizen that we must protect our children from teaching that gay marriage is okay. And Dr. Meyer testified that the stigma propagated by Proposition 8 is that it's not okay to be gay, that it's abnormal, unusual, certainly not okay, and is a basis for rejection of the individual. The experts testified not only that same-sex marriage would not harm the institution of marriage or diminish heterosexual interest in marriage, they explained as well that the elimination of discriminatory barriers to marriage and harmful stigmas would, as it has in the past, strengthen the institution of marriage and strengthen our country. We are not talking, just talking about the couples who wish to get married. We are talking about their children. In 2005, there were 37,000 of California's children living in households headed by same-sex couples. The evidence was uncontradicted during this trial and overwhelming that the lives of these children would be better if they were living in a marital household. Even Mr. Blankenhorn, the proponent's principal witness, agreed with that proposition. And here we have another excerpt from the testimony of Mr. Blankenhorn.
You believe that permitting gay and lesbian couples to marry would significantly advantage the gay and lesbians themselves and the children they are raising, correct, sir?
When you say advantage, do you mean improve the well-being of?
Yes.
Well, my answer to your question is that I believe that adopting same-sex marriage would be likely to improve the well-being of gay and lesbian households and their children.
That is the plaintiff's principal expert witness, that approving same-sex marriage would be likely to improve the well-being of gay and lesbian households and their children. I was stricken by Mr. Blankenhorn's testimony about the other societal benefits that would arise from permitting gays and lesbians to marry. Mr. Blankenhorn admitted on the witness stand that same-sex marriage would yield numerous societal benefits. I don't have time to do all of this, but I want to play two excerpts. Here's one.
The seventh positive consequence, which you agreed with, was that gay marriage would be a victory for worthy ideas of tolerance and inclusion. It would likely decrease the number of those in society who tend to be viewed warily as other, and increase the number who are accepted as part of us. In that respect, gay marriage would be a victory for and another key expansion of the America idea, the American idea. And I have read those correctly, have I not, sir?
Yes, sir.
He testified that it would decrease the number of those in society who would be viewed wearily as other. In other words, not okay. And the elimination of that stigma and that discrimination, according to Mr. Blankenhorn, would be a victory for the American idea. He went on to say something somewhat along the same lines, but it's important to recall it.
Direct your attention to. You say, I believe that today the principle of equal human dignity must apply to gay and lesbian persons. You see that?
Yes, sir.
And the I there is you, correct?
That's correct.
And you say, in that sense, insofar as we are a nation founded on this principle, we would be more, emphasize more, American on the day we permitted same-sex marriage than we were on the day before. And you wrote those words, did you not, sir?
I wrote those words.
And you believed them then, correct?
That's correct.
And do you believe them now, correct?
That's correct.
So the plaintiffs, he's the proponent's principal witness, believes that gay and lesbian individuals would be better off. Their children would be better off. We would be closer to the American ideal or the American idea in applying, he said, the principle of equal human dignity upon which this country was founded. We will be more American the day we permit same-sex marriages. That is the proponent's principal witness. And that, Your Honor, is the four perspectives that we saw in this case about marriage. On the one hand, we have the proponent's arguments that it's all about procreation and institutionalizing, deinstitutionalizing marriage, but was not supported by credible evidence. I couldn't find it. That's the one hand. On the other stands the combined weight of 14 Supreme Court opinions about marriage and the liberty and privacy of marriage. The testimony of the plaintiffs about their life and how they are affected by Proposition 8. And the combined expertise of the leading experts in the world as far as we were able to find. It's no contest. So, Your Honor, it's important to emphasize the plaintiffs have no interest in changing marriage or deinstitutionalizing marriage. They desire to marry because they cherish the institution. They merely wish for themselves the status the state of California accords to their neighbors, to their friends, their co-workers, and their relatives. The plaintiffs are in the same position as Mildred Jeter and Richard Loving, who in 1967 had no interest in diluting the institution of marriage. They only wanted to marry the person they loved, the person of their choice, who happened to be a person of a different race. That's all the plaintiffs desire, the right to marry the person they love, the person of their choice, who happens to be of the same sex.
Mr. Olson, at the beginning of the case, Mr. Cooper said, "Judge, this case involves legislative facts." We just heard much of the testimony. Would you agree with that characterization?
I felt at the beginning, Your Honor, and we made this point at the motion for a preliminary injunction, that Proposition 8 on its face discriminates against a class of individuals. It does the same thing. And I was going to mention this in a moment, and I probably will emphasize it in a moment. It does the same thing that the Romer decision, by taking away a class of rights from an individual, a group of individuals, a classification of individuals, to take away their rights based upon their sexual orientation. That's exactly what this case does, Proposition 8 does. And harking back to Lawrence v. Texas, the Supreme Court of the United States said that the conduct which characterizes sexual orientation in this case is a protected constitutional right. So Proposition 8 takes away the fundamental right to marry from a class of persons based upon their practice of something that's been decided to be a fundamental constitutional right of liberty, privacy, and association. And I believed
Is
then...
there a yes or no in all of this?
Yes. Well, yes and no. Yes, I believe this case could be decided on whatever Mr. Cooper means by legislative facts. But the facts that are apparent from the proposition itself, from what we know and don't need a trial to prove, that these people are being selected out on the basis of their sexual orientation. And what the Supreme Court says, has said consistently again and again about the fundamental rights involved here. I think you could have made that decision. You decided that we should have a trial to examine the facts. Marriage, the classification of individuals, what marriage means, what it's like to be taken away, what is the effect of discrimination, what is the history of discrimination. And now I think that that was an exceedingly wise decision, because whatever you decide, we now have not just the Supreme Court decisions and not just what we know about discrimination on the basis of sexual orientation, but now we have heard what it really matters like in real life. We know what it's like from the experts, and we've had an opportunity to explore these things. This has been a great education. I think not just to the people in this room, but the people who read this record.
Well,
and I might add, this is the kind of record that was created as an antecedent to the Supreme Court's decision in Brown v. Board of Education. It's the kind of record that was created in the VMI case and other cases of discrimination. And so the legislative facts, what I really don't, honest to heavens, know exactly what legislative facts are, or I wouldn't try to distinguish them. But the facts that we do know as a result of the Constitution, what we know about people, what we know about the classification, those support a finding that this is unconstitutional.
Well, I assume the term legislative facts refers to facts that it is appropriate for the judiciary to decide or not to decide, and that is a distinction that Mr. Cooper is attempting to draw. So when is it appropriate for the judiciary to weigh in on legal and constitutional questions that may touch on sensitive social issues? What are the criteria that a court should look at deciding whether or not to render a decision that a certain right or a lack of right implicates constitutional considerations? When does it become ripe for the court to weigh in on these issues?
Well, I think that it undoubtedly depends upon what the state is trying to do, how that state's actions is going to affect citizens. And if we turn to the 14th Amendment, not just citizens, but persons. And I think the cases are going to be different depending on those things and certain other related facts. But if I read the cases going back to 1888 on the due process part of the marriage right, and if I read the cases going back to Yik Wo decision in 1886, where the Supreme Court struck down the right of a Chinese person in this city to operate a laundry, I look back at those decisions and I think what the court is doing is making an appropriate judgment as to whether or not it needs more information about what the state is trying to accomplish, whether its objective is being served in a narrow basis so that it's not over-inclusive or under-inclusive. Those kinds of facts that we learned during the course of this trial, I think, aid the decision that you're being expected to make, and will aid the record that the decision will have before it, with it, when it's reviewed in the Court of Appeals, and aid in the understanding by the American people what the rights are that we are talking about. I think at the end of the day, as I said, I thought we didn't need the trial. But at the end of the day, I think it's an enormously enriching and important undertaking.
Well, now, the Supreme Court of the Baker versus Nelson case decided that the issue which we are confronted with here was not right for the Supreme Court to weigh in on, and that was 1972. What's happened in 32 years since 1972?
Well, a great deal has happened. Among the things that have happened is the Romer case. Among the other things that have happened is the Lawrence v. Texas case. You know what those cases involve? A lot of other things have happened. Changes in the ballot propositions. California has adopted something completely different than the state, I guess it was Minnesota or Michigan, involved in that case. So there are a lot of factual situations that are different. This case is very different. And by the way, the Supreme Court rejected the opportunity to take a miscegenation case. Now, I think it was, Dr. Cott testified to this, I think it was 1955, and then they took the case, the Loving case, in 1967. The same issue was before the court, I think, also in the Zablocki case, where there was a summary affirmance of an earlier case. I take that back. It was Turner v. Safley, the case involving a fundamental right to marriage for prisoners. Turner v. Safley. The Supreme Court in
What year was that?
Pardon?
What year was that? One of your colleagues will get it for you.
I have that very close by, but I will.
In any event.
At any rate, I thought that was interesting. We talked about it somewhat it was 1987. But it talked about the fact that the court was urged to said the court had already decided that case because it was an earlier summary affirmance in that case. And the court went on to take the case. It pointed out, like that Mandel case that cited with respect to summary affirmances cases, the facts were different. The time was different. A lot of things happened since then. And the court, the lower courts and the Supreme Court, were not bound by that prior summary affirmance. We have learned so much in the years since that case, or that summary affirmance, but we have also learned a lot from the Supreme Court. Remember, the Supreme Court in Lawrence v. Texas reversed Bowers v. Hardwick, which was only 20 years earlier. That's a big difference. And what the Supreme Court, the opinion for the Supreme Court in Lawrence v. Texas quotes and makes a part of its holding Justice Stevens' dissent in Bowers v. Hardwick, there couldn't be a more complete shift in point of view in that period of time.
Well, it's apparently changed the point of view by Justice O'Connor.
No. Lawrence v. Texas was a 6-3 decision. She wrote a concurring opinion on equal protection grounds, but the majority of the opinion was signed by 5. Justice Kennedy and 4 other justices decided that case on the basis of due process. And the Romer case, which involved sexual orientation in Colorado not very many years ago, the late 90s, I think, decided to reject a class of discrimination on the basis of sexual orientation. Those Supreme Court decisions inform our decision.
How important in that case was the fact that the initiative measure in Romer took away the voters of the municipalities of Colorado the opportunity to pass anti-discrimination ordinances, as opposed to simply a blanket prohibition against the enactment of those initiatives in the first place?
Well, the court said it was significant that there was a taking away of rights. I don't know what I would have decided if that had been the blanket prohibition of the granting of those rights. We've had cases like Romer, though, going back to Reitman v. Mulkey in 1964, where the citizens of Colorado decided to rewrite its constitution. California, to rewrite its constitution, was Proposition 14.
Is that housing?
Fair housing. That was the fair housing issue. And the voters of California said, we're going to amend our constitution and we're going to repeal all the fair housing statutes and affirmatively give a right to any citizen to sell his or her house to whoever they wanted, irrespective of race. That went to the United States Supreme Court. The Supreme Court said, we can discern, speaking of legislative facts, we can discern that the motives involved in that were taking away rights of individuals that existed in that case on the basis of race. Then comes the Romer decision. There's an intervening case involving busing from the state of Washington that goes to the Supreme Court, where the voters again did something to their constitution to change issues with respect to civil rights. Similarity here is that in Romer, individuals were protected by state laws from discrimination on the basis of sexual orientation. In California, individuals lost the right to marry on the basis of sexual orientation. And the Supreme Court said, you've taken away the rights of these individuals for redress. The only way they can seek redress is to go to their fellow citizens and amend the Colorado Constitution. And the plaintiffs here, the only thing they can do to restore their rights is go to the citizens and seek to amend the Constitution. So, in each case, rights are being taken away because of sexual orientation, and the barrier is placed in the Constitution.
Let's see if I can get an answer this time. Would this case be different if California had never permitted same-sex marriage?
It would be different, but would still be unconstitutional because it is a stronger case because there were 4 categories of citizens. It is a stronger case because the California Supreme Court said in the California Constitution there is the right of an individual to marry someone of the same sex. And the citizens
So the facts here are stronger simply because there was a period of time, albeit 6 months, in which the state of California permitted same-sex marriage.
I submit that is correct, Your Honor. And the political scientists that were here talked about the initiative referendum process by which minority rights are particularly vulnerable because they don't have any room to negotiate. Their rights are being put up for...
What kind of constitutional system is it that because of a California Supreme Court decision, which has a shelf life of 6 months, that creates a greater entitlement than if the right had never existed in the first place?
Well, the California Supreme Court, I think, would say that we didn't invent that right. We determined when it was brought before us that the California Constitution, which we are not changing, we are interpreting, contains that right. Now, and that has happened again and again where courts recognize the discrimination that it's imposing upon citizens. We could say the same about the separate school in Texas, the law school, Sweat v. Texas, Painter v. Sweat. I can't remember exactly the name of the case, where Texas set up a separate school system, a separate law school for African Americans. We could say the same thing about Virginia in setting up a male-only Virginia Military Institute. We could say the same thing about Plessy v. Ferguson. Where in the world in 1954 did the Supreme Court come up with this right that didn't exist right before then? So I think that it is a more forceful fact because of the Romer case, and because of the taking away of rights. But I hasten to say that if this case, we were writing on a clean slate, which we might be if we were litigating the same issue in the next door state, I would be making the same arguments. You are, the citizens of XYZ state, are selecting out people on the basis of sexual orientation, a practice which the Supreme Court says is a constitutionally protected right. And you are putting them in a separate category with respect to another fundamental right, the right to marry.
The statute in Lawrence was a criminal statute.
Yes.
Denial of the right to marriage of same-sex couples does not have any criminal implication or sanction. There isn't any sanction that attaches to it. It's simply a denial of access to the estate of marriage. That's not a criminal penalty.
I submit that it doesn't make any difference. If we're talking about, once Lawrence v. Texas recognized the constitutional right to, what the court repeatedly talked about in Lawrence v. Texas is the right of individuals, the constitutional right of individuals. That is on page 574 of the Lawrence opinion. Our laws and our tradition afford constitutional protection to personal decisions relating to marriage, procreation, contraception, family relationships, child rearing, and education. That's not a complete list. And then the court goes on to say, persons in a homosexual relationship may seek autonomy for these purposes just as heterosexual persons do. The court was talking about the private, intimate behavior. If the court had said, instead, you can go to jail for 5 days because we caught you doing those things, we will take away your right to drive on highways, we will take away your right to marry because you do those things or you engage in that conduct, that seems to me that that is just as unconstitutional, especially if the thing which is taken away is also a fundamental constitutional right. In other words, because you engage in something that's protected by our Constitution, we're going to take away because we don't like it. We're going to take away a right to do another thing that's protected by our Constitution. That can't be constitutional. And so I don't think that there is any distinction. I submit that there can't be any distinction. And the language of the decisions talks about the individual right to engage in that activity. That can't be a precondition for engaging in the right to marry.